You can venue away from a judge if you don't think he or she will be fair to you. Despite some of the things I've said, and will say, out loud or under my breath, about Judgeapu, I always tried to keep my cases in his court, despite the danger to my ego and the risk to my poor beleaguered ears. I knew my clients were better off risking a dressing down than taking a chance before a better-mannered, but not quite so honest magistrate. So, I was happy to practice in his court, despite what one of my colleagues observed.
That man has the charm of a teased rattlesnake.
I always disagreed. Judgeapu had the charm of such a reptile all right, but only when he was in a good mood. Despite his explosive demeanor, Judgeapu was dependably fair. Usually, when I got one of his orders, I felt like I had heard the same evidence Judgeapu had heard, and even if I disagreed with his conclusions, I could understand how he reached them. Not all jurists were that reliably consistent about ruling on the actual facts of a case. I met several judges in my travels who suffered from a contagious malady we discerning practitioners call black robe disease. My client has been charged with a DUI, which is legalese for driving under the influence of intoxicants. In this case, it was alcohol and a little weed just to liven things up for the authorities. You see, the powers that be, not to mention other drivers, get a little cranky when a body has trouble identifying what side of the road he can call his own. I believe my dad expressed that sentiment best at a few passing cars, usually just as my mom dozed off in the passenger seat.
Charlie, stay in your own damn lane, you idiot. Are you trying to kill someone? I can't believe some people have driver's licenses. Idiots. That must have been drunk. Where are the police when you need them?
My client went to court on these two charges and was given a suspended sentence on the DUI and a conditional discharge on the marijuana rap. Her suspension for DUI was revoked, and she served the time for it. The cops released her, and it appeared that all was right with the world. About a week after her release, the sheriff called her and asked her to turn herself in to finish serving her sentence. It appeared that she hadn't served the additional time called for under the conditional discharge. This kind of disposition means that if you don't get in any more trouble during your probation period, the prosecutor will dismiss the charge. If you do get caught doing something naughty, all bets are off, and your original sentence returns like a pizza dream. In this case, I'm not at all convinced that my client had done something naughty, but in my opinion, the judge certainly did. The woman hired me to help her beg for mercy. Looking at her case, I was sure she didn't have much to worry about. She was charged with drinking before turning herself in for her weekend visit to the lockup. What she allegedly drank wasn't enough to make much of an impression on the breathalyzer machine. Unfortunately, the judge was more easily impressed and felt a strong inclination to throw my client in jail with the rest of the town's murdering scum. Among the facts I cited for relief is that the reason she had been revoked originally was that she blew a Porozoa 1 alcohol reading when she reported for one of the 5 weekends she was supposed to serve as a term of her probation under her original sentence. To show you how minuscule that amount is, bear in mind that you have to register NORI 8 to be considered too drunk to drive in Indiana. Heck, she was 7.9 points below the level necessary to be considered publicly intoxicated in this state. The prosecutor was afraid to agree to modify the sentence. Being reasonable was not a good precedent to set. Justice and mercy be damned. The judge, too, was in no mood to be reasonable. He felt that even though she had served a revoked sentence for her DUI, life wouldn't be complete unless she did the additional time for her conditional discharge. So you have a situation where she was at less than 0.1%, which is 7.9 points less than the amount needed to be driving illegally, and she ended up in jail for 5 months for something she didn't do, which was drink. She thought it was possible that the soy sauce she used or some candy she ate may have registered on the sheriff's equipment, which resulted in a false reading. Frankly, I think the breathalyzer was a bit out of kilter. I think the judge was even more so, especially after I was done with him. Please, Judge, you can certainly see that forcing Ms. Jones to serve 5 months in jail on such a small violation that may not have even happened is a bit unfair.
So, it is your contention that this woman shouldn't have to execute her sentence because you know better than the General Assembly, the prosecutor, and the Sheriff's Department.
Well, sir, I would respectfully submit that the law gives you discretion. In this situation, the state is too harsh. If there was any alcohol on her breath, it couldn't have been enough to revoke her probation. After all, She only blew 0.1%. That is hardly drinking.
Are you questioning my integrity, Miss Uttermolen? Are you saying I am unfair because I am following the law?
No, sir, it's nothing like that. In fact, the General Assembly is the reason you don't have to impose the whole sentence when there are mitigating circumstances. My client's alcohol reading was so low as to suggest the results were not correct. I am merely suggesting that it must not have been the state's intention to impose a draconian sentence in all cases. It is obvious that the court can exercise its own judgment in extenuating circumstances.
Miss Uttermolen, you should be careful what you say to me. I am the state. When you say the state is being unfair, you are insulting me personally.
I tried again to explain that I was not attacking him personally. I was just asking for mercy from my client. Asking for mercy may seem like a waste of time to some, but I always thought it was part of a defense attorney's job description. After all, the result of a strict application of the lady's sentence wasn't justified, and the judge did have jurisdiction and authority to modify her sentence. Now, if he only had a sense of fairness. My poor client had to serve 6 months in jail. What possible benefit does society gain when one of us citizens is treated so harshly? Shouldn't there be room to reconsider results when they are so far out of line with what is being punished? Even one drink would have netted a higher reading unless the breathalyzer was way out of whack. Even if a defendant, say, took a swig of cough medicine or mouthwash before going to jail, the reading would have been higher. It is more likely that the breathalyzer was out of whack than that even soy sauce or candy was to blame. Shouldn't a judge be allowed to, say, expected to use a little common sense? It is a sad fact of life that those who seek power are often the least capable of exercising it wisely.